What issues should I consider when reviewing my beneficiaries? Let's break it down on this episode of the Hawaii Retirement Show. All right, welcome everyone. Thanks for tuning into this episode of the Hawaii Retirement Show. Today's episode, we're talking about what issues should I consider when reviewing my beneficiaries. So we're talking beneficiaries today. And beneficiaries, it's an important topic, a critical topic that's often, I wouldn't say overlooked, but reviewed less frequently than maybe it should be. And it's not super complicated, but there is some important things to consider when you go about naming beneficiaries and reviewing your beneficiaries. So there is a little checklist here, Hawaii Retirement Show checklist that I'm going to touch through as well, and it'll be posted on the website. But before I do that, I want to bring up a couple things recently that have come up in discussions with either clients or friends regarding beneficiaries. I thought it'd be a good way to kick off the episode. So the first one is regarding naming. So you can name beneficiaries, and then you can name contingent beneficiaries, right? Which would be second order. And then you can name tertiary beneficiaries, third level. Not all custodians or whatever the account might be may allow to have tertiary beneficiaries, right? At some point, it doesn't stop. You can't just keep going fourth level, fifth level, and so on and so on. But with that being said, there is something called per stirpes and per capita that can play into this equation, right? And I'm going to kind of touch on that. But somebody, a client of mine asked me recently, is it worth naming tertiary beneficiaries? And should I name my parents, even though they're older? And it's kind of unlikely that the child would predecease the parents. And my response is, well, sure, why not, right? I mean, if they're giving you an option to name a contingent beneficiary or tertiary beneficiary, then somebody's better than nobody, because it's very unlikely, right? It's very unlikely that your primary beneficiary won't be there when that time comes. But in that unlikely event, there's a contingent beneficiary, and then in the unlikely event that person's not there, then it can go to the tertiary. And my response is, sure, why not, right? I mean, if you don't have anybody else to put down and you want to put your parents down as a contingent or tertiary beneficiary, it's not going to hurt anything. It's only going to help in that rare instance that that does happen. I would say it's better to put somebody than nobody. And then the other part we want to get to is per stirpes and per capita. So this isn't always offered. It's kind of hard to find sometimes. It's usually a checkbox on some accounts, some beneficiary forms. And per stirpes, what that means is, it's going to be hard to follow, but let's just say, okay, let's say you have a parent and two siblings. Two children, sorry. Parent, two children. Two children are named beneficiaries. Each children has two kids. If you name each child as the beneficiary and per stirpes, if one of the child passes away, their share would go equally to the two kids. So the grandkids in this instance, right? So the one surviving child gets his 50%. His children, the grandkids on that surviving child's side, don't get anything. But because the other child is deceased, then their share essentially passes through equally to their heirs, right? Their children. So they would get 50%. And this tree can get, pretty big if you start to have, multiple kids and multiple there. But naming per stirpes kind of says their share goes to the next heirs there. Per capita is different in that, let's take that same situation there. Parent, two kids, and then each kid has two grandkids for the parent, right? Same situation. If they were named per capita, instead of the surviving child getting 50% and then the other 50% going equally to the two grandkids on the deceased child's side, now it's going to be split three ways, because it's kind of like the heirs on the deceased beneficiary side step up a level, so now they're equal with the surviving child. The two grandchildren of the deceased child step up to equal share with the surviving child, and so now it's going to be split three ways: 33% to the surviving child, and then 33% each to the two grandchildren of the deceased child. Again, I know it's hard to follow here with talking it through, but look it up, per stirpes per capita. You'll see this frequently on a lot of beneficiary forms. From what I see, per stirpes is usually the most commonly used. Per capita is probably used for less frequently and in certain specific situations. Okay, so the other thing I wanted to touch on before we kind of go through this checklist here was the fact that a beneficiary designation on, let's say, like an IRA or a 401k will supersede a will. And what I mean by that is that the will can say, divide my assets up equally among these people, right? But if you have a IRA or a 401k account or a brokerage account or some sort of account that has a beneficiary designation and it says go to John Doe is the primary beneficiary 100%, that is going to be removed before it gets to the will. So it almost supersedes what is said in the will. So if you are under the impression that my will divides assets up, I created a will and, I have this estate plan that divides assets up equally between, my children or whatever. But you have these different investment accounts, 401ks, IRAs, and retirement accounts that have beneficiaries that don't align with your estate plan and your will there. The beneficiary designations on those retirement accounts kind of wins out, right? Because it's like first order. So when you talk to the custodian of that retirement account and they say, I'm 100% beneficiary, they say, perfect. This checks out. This is yours, right? According to what we have on file. The will, and I don't want to speak as if I'm an estate planning attorney here because I am not, but a will is primarily for the remainder assets, right? It's kind of like what's left over or to designate specific assets. So, essentially the beneficiary designation on your retirement accounts will supersede what is in the will. And again, check with your estate planning attorney, your financial advisor, but that is typically what happens there. Okay, so I think we can jump into this little checklist here. And the Hawaii Retirement Show checklist, what issues should I consider when reviewing my beneficiaries? And we'll just go through this kind of quickly here. So it starts off, do you need to review your beneficiaries to ensure they are up to date? So this goes into how frequently should you check on your beneficiary designations? And I've heard, I think a good rule of thumb, and from what I hear, is about 5 years. Every 5 years, try to swing back, put it on the calendar, and check on your estate plan, your beneficiary designations, and make sure everything's up to date. Now, if you have a major life event, you get married, you have children, that calls for an immediate review, right? But typically 5 years is good. What you hate to see is you start at a company or you start an IRA in your 20s and you name somebody and you never revisit your beneficiary designations for 30 years, and it turns out you left it to your best friend's cousin because you didn't have anybody else to name at the time, and now you got a family and kids, and it's, just revisit it. A lot of times you see it going to maybe if there's a divorced couple, an ex-spouse, and they didn't want it to go to them. And so always good to check in, update your beneficiaries every 5 years, or if there's a major life event. Are your named beneficiaries different from what your will or trust dictates? So again, this is what we just touched on. And it says, remember that beneficiaries take precedence over a trust or will. So that's kind of what we touched on before we jumped into the checklist here. If you are charitably inclined, do you need to review the investments you intend to leave to charity? And yeah, you can leave. You can name a charity as the beneficiary, right? And there are some tax considerations to that. and as well as, just helping out people, right? Charitably giving, which is a great thing. So it's always good to check on that. Do you need to review the plan proportions of qualified and non-qualified accounts being left to your heirs? And what this is referring to is the tax planning side of things. Typically we see, you want to leave, parents leave equal shares to their children, regardless of their economic situation and what they have going on. But let's say one child is a high earner right now, and if you leave them, let's say your traditional IRA, something that's going to have high RMDs and some taxes associated with it, and they're already paying a lot in taxes. Maybe that's detrimental to them, and you want to leave that asset that's going to generate a lot of taxes to the other child who's in a lower tax bracket, and then they can pay taxes at a lower rate for that inherited asset. So there is some tax planning that goes into this, and you can kind of look at. I think a lot of people just take a big pie and divide it up equally. But you can go through asset by asset and look at, well, how can we best position this to our heirs so that they're not hit with a huge tax bill and it benefits everybody, the best way. Okay, moving along. Do you have your estate listed as a beneficiary? So, I would say the only thing with this is just keep in mind your estate will be subject to probate, right? So you can name your estate, and naming your estate is not naming your trust. It's naming your estate, and that'll go through probate. If you name a trust, that's different, right? That takes us to our next one. Do any of your accounts have a trust listed as beneficiary? And a trust passes through the trust, right? It doesn't pass through probate. But with the trust, it's kind of the same thing as the beneficiaries. Make sure the trust is up to date. Make sure the trust is funded with the assets you think are named to the trust. And you can name a beneficiary, right? Let's say you name your IRA. You take your IRA and you name a trust the beneficiary of your IRA. Your IRA is then going to be passed to the trust. But a trust can also hold other assets, and a lot of times people don't fund the trust, right? So let's say I create a trust, and my intention is to put my second home in the trust, right? But I already have my first home in the trust, but I never changed the title of my second home to the trust. So technically, the assets aren't part of the trust. Just because you have the trust is a wrapper. It's like an entity, an account. But until you transfer assets in, they're not actually owned by the trust, and so they can't be distributed by the trust. But you can name a trust as the beneficiary, and you want to check on your trusts for, take a look at what those tax implications are of naming the trust, and then make sure your trust is up to date and relevant for what you're trying to accomplish. Okay, two more. Are you concerned about your heirs subject to unfavorable RMD rules, right? And this is for inherited IRAs. So when you inherit an IRA, not a Roth IRA, but a traditional IRA, there you are still subject to RMD rules, and the rules surrounding inherited IRAs is clear as mud. It's very complicated. It changes. It has changed recently with Secure Act 2.0, and there was this kind of period where there was kind of uncertain, especially during COVID. What is when Secure 2.0 came out? A lot of these rules around RMDs for inherited IRAs, but again, this goes back to the tax conversation of maybe you want to look asset by asset and look at the tax implications, including RMDs, and decide who best to receive that asset. Okay, last one. Are you concerned about an estate tax liability? So, this is important. We're coming up here to see what the Tax Cuts and Jobs Act should be renewed, and the federal estate tax exemptions to still be up around the 12 million, whatever it is, 12.5, I think, or 13 million. But there is a state estate tax as well that your estate can be subject to. And positioning assets, if you're getting close to, that estate tax threshold on the state or federal level, can maybe better help your heirs, your beneficiaries, make the most out of their assets, right? And you want to pay your taxes. Your taxes support the country. You're not trying to what's the term? You're not trying to avoid taxes. You're just trying to not pay any more than you need to, right? The rules are out there. They're not loopholes. They're just rules, right? There's a set of rules of how you can position yourself to pay taxes. And you might as well, use those rules to the maximum ability and pay the least amount of taxes possible. So if your estate is going to be subject to this estate tax liability on the state or federal level, maybe there's some things you can do through naming beneficiaries or moving assets while you're living to better position yourself to avoid that. All right, I think that about wraps us up for what issues should I consider when reviewing my beneficiaries. As always, if there's anything you'd like me to talk about in particular on the show, email it over to aloha@hawaiiretirementshow.com, and I'll catch everyone on the next one.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Cutitta and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by ToBA Financial. For Jason Cutitta, investment advisory services are offered through ToBA Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.